In the previous lesson, what we did was introduce the concept of unregistered title, and we examined the first of the major questions that are asked when it comes to the purchase of registered title, the transfer of registered title, or unregistered title, should I say. And this involved, of course, looking at the proof of ownership of title, which involves looking at deeds to property. This lesson is going to start talking about the various third-party interests that may exist over the unregistered land that we may have. And we'll talk firstly about the doctrine of notice in this lesson. We'll then talk about this in context with the different kinds of notice which is given, things like constructive notice and imputed notice, for example, before talking about land charges and the land charges register when it comes to equitable interests in unregistered title. So, as I've mentioned, we introduced the subject of unregistered title, and we also identified some of the major considerations which we shall be examining further. We're going to begin by talking about the doctrine of notice in this lesson and the next few lessons, as I've mentioned. Now, as a recap, as a general introduction, and as a general background to the concept of the doctrine of notice, let's just go back over the main considerations that we are looking for when we are examining whether or not to purchase, for quite a considerable sum of money, for most people at least, unregistered title. Okay, so we noted that there are usually two considerations which have to be acknowledged when it comes to registered title conveyancing. Even unregistered title, registered, unregistered, any kind of title conveyancing, owing to the complexities, the legally and logistically complicated process by which the purchase of land essentially takes you, and owing to the considerable amount of income that is required to even purchase land in the first place, never mind the considerable amount of money that it takes, and the amount of savings that is required for most people to purchase registered or unregistered title, there are two questions that have to be asked when it comes to the making of this purchase. Firstly, we want to make sure that we know who owns the title. We want to make sure that the individual who we are going to go through a quite long, legally and logistically difficult process and essentially ultimately hand over quite a significant sum of money to, we want to make sure they actually own the title and have the right to sell that title. That's the first question. The second question is, once we have purchased said title and we want to then enjoy the title, we want to make sure that there are no other third-party interests which may bind me as a purchaser. And so, as a result of which, we have to first, when it comes to unregistered title, talk about the concept of the deeds of ownership, when and going back at least 15 years, or at least a conveyance of at least 15 years. But when it comes to third-party interests which bind the purchaser, this is a little bit more complicated. Okay, we examined the first of these in this lesson, in the previous lesson. But when we look at the idea of third-party interests, we have to think firstly about the delineation that is made between legal interests, which will automatically bind a purchaser. They are good against the world, if you will. Okay, and equitable interests, some of which may bind a purchaser. Some others will not bind a purchaser. And for those interests that are not bound to a legal purchaser, that makes you, as a legal purchaser, equity's darling. You are the person who is able to essentially override any of these equitable interests. So we noted that already they are indestructible when it comes to legal interests. They are indestructible. Legal interests will always bind a purchaser in this regard, but equitable interest may not necessarily bind a purchaser so long as the doctrine of notice is adhered to. Okay, we'll talk about charges and land charges in a few lessons' time, should I say? But for the purposes of the doctrine of notice, so long as the doctrine of notice is adhered to, then equitable interest may not necessarily bind a purchaser. Essentially, what the doctrine of notice does is gives us an indication as to whether or not an equitable interest is given priority over a purchaser of the estate. So the concept of priority is something that we're going to keep coming back to when we go through both unregistered and registered title system. Ultimately, when we think about the purchase of title and when we think about various interests which exist over land, whether that be unregistered or registered, there are systems of priority that exist. Okay, so you have some legal interest that may exist. You also have some equitable interest that exists. These interests may include the actual ownership, the fee simple. It may include an easement. It may include a restrictive covenant. It may include anything of that kind of regard. Now, the question is, which of these interests have priorities over other interests? It is not the case necessarily that the time at which you purchased or had gained an interest in the land, that gives you the priority over anything that subsequently comes after it. Because ultimately, if you have a legal transfer of title and you become a new legal owner, you might be able to essentially jump the queue and have priority over the equitable interest that may exist before your purchase of the title. But it also may not be the case that this is true. It may be the case that an equitable interest has priority over the purchaser of an estate. And this is what the doctrine of notice governs when it comes to unregistered title. This is also something that is not governed by the Land Charges Act of 1925, which is a sort of separate system by which we can identify interests in unregistered title. So ultimately, the question here is, in order for a purchaser to be free from an equitable interest, which is not registrable under the Land Charges Act, okay, so we're talking about things that are separate to land charges, a purchaser must show the following elements, which encompass this idea of the doctrine of notice. They must have acted firstly bona fide, okay? We'll get to what this means in a second. They must be the purchaser for value. Again, we'll get to all of this in a second. They must have acquired the legal estate/interest. And then finally, there must have been no notice of the equitable interest. So the doctrine of notice is sort of encapsulated mainly in the fourth of these requirements, because they must have had no notice of the equitable interest, and we'll talk about what notice means and how notice can be provided in this lesson and future lessons' time. But there are also steps that are required beforehand. So they must have first acted bona fide, they must be the purchaser for value, they must have acquired the legal estate/interest. So let's begin with the first of these. What does it mean to act bona fide? Okay, well, very simple. It just means you have to be a purchaser who has acted in good faith. That's what bona fide means, the Latin phraseology. So ultimately, if you are the purchaser of the estate and you are entering into a transaction and you are looking to essentially free yourself from any equitable interest over that estate that is not registrable by land charges, the first thing you have to do is make sure that you have acted in good faith. You have not acted in a way which is fraudulent or dishonest. That's step one in order to achieve this goal of essentially jumping the priority queue when it comes to equitable interests. This is often quite easy for a purchaser to show. For the most part, people don't act fraudulently or dishonestly when it comes to the purchase of land. Some people do, obviously, but for the most part, you can show that you have acted in good faith. The next question is about the purchase for value. The purchase for value requirement essentially means that if an individual has received the estate as a gift, or maybe has received the estate through inheritance, they will always be bound by the equitable interest. There has to be valuable consideration in the purchase. So essentially, this is often done through money. So consideration in the sense that, if for those of you who have studied contract law, it's a similar thing. You're getting something for something else, okay? And if you are purchasing estate, you are getting the estate in return for some kind of value. And this value is often defined in money. So you are purchasing for money. So this essentially delineates those who are actually purchasing estates from those who are gaining estates through gift or through inheritance. So that's what this particular requirement shows us. They must be the purchaser of legal estate or the legal interest. This simply refers to the fact that the purchase of which you are relying on the doctrine of notice has to be a legal interest in the land and not an equitable one. You cannot rely on an equitable interest in the land to essentially gain priority over other equitable interests in the land through the doctrine of notice. The doctrine of notice is a requirement for legal interest in land to try and essentially jump the queue of priority over equitable interests. It does not defeat equitable interests if it is an equitable interest in and of itself. If you are purchasing an equitable interest in the land, then you will be bound by the previously existing equitable interests where they do bind you. So essentially, this comes into the idea of equity, one of the essential maxims of equity, which suggests that equity acts temporally. So where there are multiple good claims in equity, it is those that came first that take priority, and so essentially allows the rule of equity, which is, i.e., the rule of first in time, first in right. So where there are two equitable interests, both equally valid equitable interests, it is the one that comes first that is the one that is bound, that you have to be bound to. This essentially, like I've said, refers to previous maxims of equity which exist, which essentially solidifies equity as a broader concept as acting temporally. So where there are multiple good claims, it is the ones that come first that are the ones that essentially bind the others. So then the final requirement relates to the idea of notice itself. There has to be no notice of equitable interest, okay? So assuming you've acted bona fide, assuming that you have purchased the legal title for value, assuming that the title, like I've said, is actually legal itself, and assuming you have been given no notice and you have done a proper inspection of the property and you've been given no notice that there is an equitable interest, then the doctrine of notice will apply. So this is the consideration that must be given as to whether or not a purchaser was given notice as to the existence of equitable title or equitable interests. So there are three main ways in which notice is given. We will talk about the first one in this lesson, and then we'll talk about the other two in future lessons' time, the other two being constructive notice and imputed notice. So the first of these, though, in this lesson is the most obvious. Has the purchaser of an estate, of the legal estate, been given actual notice? Okay, actual notice just refers to whether or not the purchaser was given the information and actually knew of the equitable interest at the time of their purchase. According to the case of Lloyds and Banks from 1868, if the purchaser has in some way been brought to an intelligent apprehension of the nature of the interest which has come upon the property, so that a reasonable man or an ordinary man of business would act upon the information and would regulate his conduct by it. This is essentially what the idea of actual notice tells us. If you have been given the information at the time of the purchase, and if this information is such that a reasonable human being, a reasonable man or an ordinary man of business, in inverted commas, note the archaic language because of a case from the 1860s, then you will be bound by that equitable interest. Okay, this is an objective test, as you can see from the Lloyds and Banks ruling. Whenever you see the phrase reasonable man or ordinary man of business, okay, you're talking about an objective test. You're talking about a reasonable person test, ultimately. So if a reasonable person was given the information that you were given, and if that reasonable person came to the conclusion that there was an equitable interest that would be bound to you, then you are bound to that equitable interest, essentially, okay? It means that the purchaser has been given actual notice of an equitable interest. This does not mean that this is the only kind of notice that exists. Like I've said, there is a constructive and imputed notice, both of which we're going to look at in future lessons' time.